allegedly allegedly কথাটা ঢুকিয়ে দেবে
FIR everything
allegedly is a great seal for the accused person. Allegedly.
otherwise will not be my learned friend will not challenge an FIR.
Yes.
For anticipatory bail, he will just plead in, go to the court and plead is guilty. FIR has to be
আচ্ছা এখানটা এটা লিখুন যে একদম প্রথমে কাস্টোডিয়াল ডেট
Item number 27.
This is an application for restoration.
Respondent number 3.
delay is there, no delay within time,
6 months, 6 months, or 1 year to
only 6 months. What is the application for condonation of delay?
delay হয়েছে?
Can 1 and can 2 or same application? Have you made the prayer for condonation of delay?
Oh,
The judgment of justice in the matter, you can make a single application, but you have to make a prayer to condone delay and then to restore. Court is not hyper technical, but you have to make.
may I restoration, may I, my lord? May I restoration?
Normally we don't.
But you have to file an application for. So you take leave and file an application for condonation of delay. Your learned friend, body language says that he will not oppose.
At least a prayer should have been there.
My learned
I will
friend-
not approve.
my learned friend intimated me that there is no requirement for filing that.
Okay, but prayer is to be made. Justice in the match. EIR 99 Calcutta 29. But Mr. Sanlalan Mukherjee, it will be a, if once it is accepted, it will be convention. The grounds you will,
Miss the list.
it is expected that in a application for restoration, the ground would be to justify the absence, but to justify the delay in preparing the application for restoration. Extension of time. Huh? Okay. This point was also read, Toilokko Singh judgment or anything like that. That section 5 is not a proceedings for which Limitation Act will not apply it proceeding. But a court has inherent power, I contradicted, stating that court has inherent power to seeking a justification for the delayed approach. Okay. Okay. That maybe in writ proceedings, the section 5 may not have any application, but court has every power to seek a justification why you caused delay in approaching the court. Toilokko Singh or anything Toilokko Singh or any judgment like that you are talking about. Yes. No, it is not a proceedings in that sense. And even there is a explanation 141 Code of Criminal explanation. It is not proceedings such as. Yes. You find the 141 section 141 of the CPC explanation that writ is not a proceeding, civil proceeding in that sense. But the principle will apply. You file an application. Otherwise, it would be convention. Everyone. You file, okay. Two pages application you file. Just application. For condonation of delay, if you go by the suggestion, extension of time to file, what you will use, file a 2 pages. Okay. Next.
Item 28.
Can you pass a order that I am paying leave to file an application under section 5?
The petitioner হবে। No delay.
No,
Application for appropriate order.
no, kindly see.
Appropriate order.
4 of the.
Perhaps.
4 of the
Lordship, Mr. Shobhan Majumdar appearing for the petitioner, some personal difficulties, he is not come to the court on that day. Lordship, kindly make it not today and then file restoration application within time, Lordship, restoration application.
Reply are not received. Evidently reply by.
APDB in opposition on behalf of respondent number plan. APDB in opposition to the writ petition. Okay. Respondent number 3. Okay, so not this week or
Not today, restoration within time, my lord, and restoration application may be allowed, Lordship.
matter maybe so there is no delay.
No delay,
It was
Lordship.
filed within time.
Within time, Lordship.
Restoration application আর হবে অ্যাপ্লিকেশন আছে এক্সটেনশন extension of interim order 30 who is for 30
I am for the respondent number 5.
I'm for the state respondent.
29 there is a 29 also. Oh, sorry, 29. Okay.
The extension that.
Eh?
30
You are seeking time.
করবে না টাইম নেবে
Time given according.
My lord, the appearing advocate is on.
Okay, not
duty-
today.
Not today, my lord.
Okay, not
No,
today.
Millard, not today, Millard, no, Millard. Millard, I am for the petitioner.
Huh?
he is
Millard, I am
no,
for
no,
the petitioner, kindly accept the interim order, Millard.
30.
Your
29.
matter is 30, it is 29. 30 is will be taken up. Don't worry. 30 now 30. ডাকুন
Now
তাড়াতাড়ি।
30.
Yes, 30.
Pursuant to direction of the honorable
30
High
Millard,
Court,
extension of interim order.
Evidence
30, 31
opposition.
both.
on behalf of the
My lord.
respondent number 5, the principal of the college.
আচ্ছা আপনি একে লিখুন তো এপিডিবি ইন অপোজিশন ফাইল অন বিহাফ অফ রেসপন্ড inform that the copy of such opposition has been handed.
Have a copy of
My lord,
the affidavit.
Petitioner, আচ্ছা
my lord, opposition, my lord, I have served the copy of the opposition to the
আচ্ছা
petitioner.
রেসপন্ডেন্ট নাম্বার 5
একটু ধর না, আমাকে দে না ওটা। দেখ কিছু দেখাচ্ছে।
Administration, I have to go through the apply. Most probably I replied might be needed. Kindly gives me the liberty. If so advised, my lord, I will file the reply. If so advised, my lord, I will file the reply.
Millard, 30 is over,
আচ্ছা the
30, 31.
petitioners and
College administration. Governing body, my lord.
oh you have no time to check up the
My lord,
cost
actually,
title
there are
also.
multiple respondents. my lord.
You have you come with your beef?
Yes, my lord. It's a soft copy, my lord. The thing is that there are
You are
multiple.
junior member of
My lord, six.
who is the your
Four and
respondent number? Either court is to
Four
find
and
out
six.
or your learned friend is to assist you.
No, my
Four
lord.
and six.
Four and six.
4 and
There
6
are multiple, my lord.
আচ্ছা
That is
আপনি
why we are
তাহলে
giving
এখানে লিখে
colleges
দিন তো ওই যে
response.
আদার রেসপন্ডেন্ট বললাম ওখানে 4 and 6 লিখে দেবেন ঠিক আছে আচ্ছা আর কি বললাম লাস্ট হ্যাঁ হ্যাঁ ওই রেসপন্ডেন্ট নাম্বার 4 and 6 কে কপি দিয়ে দিল কপি অফ দ্য সাচ এপিডেমিক অপোজিশন ইজ হ্যান্ডেড ওভার
My lord, the interim order may be extended, my lord.
If they use such affidavits shall be exchanged upon ঠিক আছে আপনি লিখে দিন তারপর আচ্ছা leaves the matter for further consideration when
My lord, they have prayed for interim order, my lord.
Yes, my
okay
lord,
okay last
interim order.
when
Any day after vacation?
leaves the matter for further consideration 4 weeks since
Yeah.
4
Yes.
weeks since আচ্ছা আজ
4 weeks.
4 weeks since আচ্ছা interim order passed earlier is extended until the end of June or until further order whichever is earlier.
Deeply obliged.
Oh,
Grateful, my lord.
okay. Whether next matter is same.
Same, my lord.
Same order.
Exact-
Same,
Same,
same.
same, my lord, I have.
So to take the copy of the
Similar matter is before your lordship, Justice Sengupta, and that has not been listed today.
In fact, if I may supply that.
78 of WPA 78 of 2025.
it was mentioned.
No, not mentioned, but suddenly this has
My lord,
come to my notice.
You mentioned this matter, you give this reminder, if
May I
you are
seek my lord's
governed by the
May I-
the issuer same order will be passed and it will also be placed along with this.
Today itself, may I hand over the slip to the court officer? my lord?
Suddenly you find the energy to just before recess. That today itself it will be.
Because the parties are same.
My lord,
Okay,
may I
mention
make-
it tomorrow. Mention it tomorrow upon notice to Oh.
Item number 1.
Madam, to the bank
Yeah.
and Lordship, I got the amended Act 2013. Your Lordship, please to ask me the date when they are gazetted notified.
When
When it was gazetted, the date when it was gazetted. The
came
amended
into
Act.
effect on 12th August 2013. Eh? Yes,
Pardon, your Lordship,
court has taken note of it.
Lordship. And the same point was decided by Lordship, my lord, in case of Nochiketa, that has been handed over to Lordship, my lord. The same point was involved there.
Order of punishment dated 28th January 2022 and order of the appellate authority dated 16th June 2022 are set aside. The respondents are directed to reinstate the petitioner within a period of a month from the date of receipt of the
It's the usual prayer, my lord, that I pray for operational safety of daughter. I'll take it, note, my lord, reject it. And then,
হ্যাঁ
can I note my submission, my lord?
স্যার আমার লাস্ট লাইনটা ইয়ে করে আফটার প্রোনাউন্সমেন্ট অফ দ্য জাজমেন্ট মিস্টার হোসেন প্লেস ফর
Fixed matter, item number 33.
33. Oh. Yes.
I move this into its application, alleging that the proceeding was initiated under the Act 1 of 1894. Well, Section 4 was published. In the Section 4, it has been indicated that Section 17 has been invoked. But fact remains, my lord, that possession is still remain with me. Even for the argument's sake, if I accept that possession was taken over, that not on the basis of Section 17, but according to them, after declaration of award. Now, my lord, when I move this application, it has been stated in my writ petition that my mother, who was the writ petitioner, because I have subsequently the present I didn't substitute, the legal years have been substituted, was served with a notice under Section 9, subsection 3 and 4. But in compliance to that,
Subsection 3A or B?
no,
3B?
Section 9. No, it's a case of it's a case of fresh proceeding under the Act 1 of 18.
Oh, sir.
So 9 3
It was, there is no question of revival.
This is not a case of 9.
Okay.
Then, my lord, I was served with a notice under subsection 3 and 4 of Section 9. Now, there is no denial that to my statement that I duly participated in the, I responded to the notice and I submitted all the documents to the satisfaction of the respondent in support of my claim. And there is no denial to this. If there is no denial to this, my respectful submission will be before your lordship will be this. Then there is no bar on the part of the collector to declare award in the name of the notice whom the notice was served, in name of my mother, since my mother was alive on that day. Now, my lord, they have filed an affidavit. Since, my lord, they have not declared an award, I sought for compensation. That proceedings lapse, so sought for compensation. If you want to continue with this under the 2013 Act.
No award was published.
But according to me, when I filed this writ application,
I'm appealing for response of 4A, the recovering authority lordships. At which
Requiring body, yes.
I gave the entire amount of money to the LA collector
LA collector.
for purchase, for acquiring the entire land lordships. So entire thing has already been completed, lordship. My learned friend finish it, lordships. I'll place all the thing. Mr.
Okay.
Chundi,
Okay, so according to you, no award was published and no compensation was paid to you.
my lord, I'm not saying that. When I moved this application, I was not served with any award notice, nor any compensation has been paid. So for the first party concerned, that award has not been declared. Subsequently, by filing of application, affidavit in opposition, they have disclosed that award has been declared. But, so for my second contention is concerned, that I was not served with a notice under section 12(2), that is admitted. What they did, even assuming that award is valid, that award has been declared, and apportionment has been done in my name, which is a mandatory in nature for the purpose of declaration of the award, but as not verified. Now, this is unheard of. Statute does not recognize this word, not verified. Neither the land acquisition manual, the executive instruction, nor the statute recognize this word not verified. A award cannot be passed saying that not verified. If there is any dispute pertaining to title of the thing, or collector was in the dilemma that he is not in a position to declare the award, then his duty casted upon him to refer to this to the civil court under section 30 of the Act 1 of 1894. That was not done. Now, my lord, when they filed this affidavit, my lord, the coordinated bench of your lordship was kind enough to ask for production of the records. Then, my lord, I took the inspection and relevant order sheets that was handed over to me. A copy whereof I have already submitted the possibility that will be in the file. Now, this is the nutshell of the cracks of the dispute between the parties. Now, kindly have a look how the award has been declared. Whether, my lord, my respectful submission before your lordship will be this: the alleged award is not sustainable in the eye of law in view of non-compliance of the proviso to section 11 of the Act 1 of 1894, which is mandatory in nature. Before I proceed with this, my lord, the order sheets, kindly have a look at the, my lord, the section itself. এটা জোসেফকে দেবেন? Kindly have a look at the, my lord, the first proviso. Provided that no award shall be made by the collector under this subsection without the previous approval of the appropriate government or of such officer as the appropriate government may authorize in this behalf. It's a mandatory in nature. If any award is being passed without being accorded approval, that is honest in the eye of law, and that award is honest in the eye of law, and there is no award. That is upheld by the Supreme Court even this while this clarifying this situation. Now, my lordship, kindly see the order sheet. My lord, your lordship will find in a bunch of papers order sheet. Kindly have a look at the order sheet.
That's it. Yes.
Now, my lord, kindly see. The relevant portion starts from
It was taken on record
yes, yes,
eh?
yes, yes.
by a coordinate bench.
By your lordship is coordinated.
Okay.
Because on the basis of that, I advanced my argument before two other benches. But subsequently, for change of determination, this is
Okay.
now, my lord. Now, kindly turn to my lord, inner page 10. Is order dated, my lord. Kindly mark the order. The 7th of February 2003.
Yes.
Schedule verification done by
Such and such.
So, schedule verification, according to me, my lord, in respect of all the land users. From the, at least from the, it appears from the order sheet. Accordingly, award has been in form of 12, 13 and 13A indicating award note is placed herewith, which may kindly be approved. So, on 7th of February, they are asking for approval. They file to be placed for approval. So, admittedly, on 7th February, there was no approval. Then kindly next, my lord, next date. There is 11th February 2023. Award in the form of 12, 13, 12 may be approved and signed. So, on that also, on that day also, the no award. All on a sudden, my lord, 17th February 2003, kindly mark it. Award has been declared. Without noting when this has been approved. Then, estimated amount, such and such, verified amount, such and such, according to sub-allotment of funds may kindly be made. But I could not follow this. Sub-allotment, I could not follow. If award has been declared, now nowhere in the order sheet, this attained from, it will be evident, this award has attained the finality, even assuming this is a valid award, because this has not been filed with the collector office, which is mandatory in nature. Then, my lord, kindly see the next page. Kindly mark it. 17th February 2003. Payment made. Now the possession of the land to be handed over to the requiring body, that is housing department. Kindly mark this portion. Therefore, my lord, after declaration of the award under section 16, possession has been taken over. Not under section 17. Not under section, because before invocation of 17, an approval is required for purpose of invocation of section 17, which is absent in this case. So therefore, from the date of declaration under section 6, award is to be made within 2 years from the date of declaration of the 6 in terms of section 11 capital A. That period is also over. Now, my lord, kindly. Another thing is there, my lord. Kindly bear with me for a moment.
Whether their notification, they mentioned the provision of section 17.
That has been mentioned. That has been mentioned. But
Yes,
possession has not
now,
been taken over.
now,
Possession has not been taken over.
আচ্ছা,
Even moreover, in terms of subsection 3 of section 17, 18% other compensation was not paid. Against the non-compliance is there.
yes, I couldn't follow.
Section 17(3)
Yes,
prescribe that if you invoke section 17(1), then you have to pay 80% other compensation. Estimated amount, 80%. That is mandatory. That has not been also paid. That has also not been paid. Moreover, my lord, there are other things also there. I shown to your lordship that award has been declared. Statute says an awards have been declared and payment has been made, that has been indicated. Now, lordship, kindly see another chapter. Can you turn to my lord? My lord, this is a page, well, kindly excuse me that inner page 15, kindly turn to inner page 15.
yes,
Inner page 15, this is order number 21, dated 7th August 2023, 2003. Justice got it. Post-award verification, my lord, not recognized by the law. Post-award verification made by such and such, along with the rectification of the post-award verification, is enclosed herewith. Accordingly, award has been prepared for rupees such and such. Estimate and award may kindly be approved. Kindly see, my lord. Earlier, they have said that award has been declared, payment made in the month of February 2003. Again, they are passing an award on 7th of August 2003. That award is to be made, approve it. And till date, not a single scrap of paper has been placed before this before this honorable court, showing that the award has been approved, and accordingly award has been made. Not a single document. One hand they are saying award made, payment done, possession taken. After few months they are saying estimate, award is to be approved. Next, my lord, kindly turn on 8th of September 2004. This is, my lord, 7th of August 2003. Then, my lord, at inner page 19, your lordship will find after 1 year, 8th of September 2004, now saying, now this amount of rupees 5,22,000 as calculated in Form 12 and apportionment shown in Form 13A and the verified schedule placed before may kindly be approved and signed. So therefore, my lord, on that day also, there is no approval. And there was no award. There was no award.
in absence of approval from appropriate government.
Because there is,
According to
there cannot, not according to me, my lord, subject to your lordship correction, this is the statute. It's a mandate upon the collector that below 5 lakhs, no approval is required according to the, my lord, their manual. But above 5 lakhs, this is a mandatory.
Now, whether this accounts is available to a land loser.
That is the only, the 100%, my lord. Otherwise, who can challenge this? May
This
I put?
provision,
My lord, Malik, kindly make it.
clearly this provision is made so that a collector can be can be forced to remain with the check and balance of the appropriate government.
My lord, this is.
Whether this defense is available to a land
My
loser.
lord, subject to your lordship correction, this defense is available to me only. This is defense is only available to the land loser only.
Okay, show any authority.
Yes. This judgment. আগে একটা judgment দিয়েছিলাম। Can I get back the file so that I can?
Yes, yes. Yes, there is a file, some judgment has been given. Someone taken note. This is a judgment. এগুলো কি হেঁটে দিয়েছে?
Yes, Rajiv Gupta. This is. Yes.
Some other judgment is tagged with the file.
Yes. Yes. This is the judgment on my lord, here also. The land loser challenged this. The matter went up to the Supreme Court. And while clarifying the proviso to the section 11, this has been held that in absence of approval of the appropriate government, award is nullity. Even my lord, Act says that if collector does not file this with the office of the collector, the award is not being filed. The award is incomplete. And only the land loser who can point out all this. Because if award is non-est in the eye of law, I cannot take the recourse of 18(2), section 18. And whether the award is non-est, whether it's subsisting or non-est in the eye of law, only the land loser can point out this thing. The opposition today. Now, my lord, lordship, kindly turn to. Sorry.
Yes.
Kindly turn to paragraph 6 of the writ petition 1.
Yes.
Paragraph 5 and 6. That on or about the 12th August 2002, the petition was served with a notification under subsection 3 and 4 of section 9 of the Land Acquisition Act 1894. At present, repeal issued by the collector being the respondent number 2 herein, whereby and whereunder the petitioner was asked to appear before the said respondent on 23rd August 2002 to state the petitioner's nature, interest, and claim for compensation history of the said land, and to lodge objection, if any, to the measurement in respect of the land under section 8 of the Act. Annexed, that in terms of the said notification dated such and such, being annexed for your petitioner duly appeared on 23rd of August 2002 before the collector being the respondent number 2 herein, and produced all the relevant documents in support of a right title interest in respect of the said land to the satisfaction of the said respondent. Now, my lord, lordship, kindly see, my lord, the state has used an affidavit in opposition. Now, I like to demonstrate to your lordship, my lord, how this has been dealt with. Page 7. page 7, paragraph 7.
Yes.
That in respect of paragraph 5, they also got it. That
Hmm.
in respect of paragraph 5 and 6 of this instant writ petition, 7 except what are matters of record, I do not admit anything contrary thereto inconsistent therewith. In particular, I say that the material facts of ownership of the petition in respect of such and such, Moja in respect of such and such, has been duly considered by the land acquisition collector.
Hmm.
So there is no denial that I am not the owner.
That when they have
That-
issued, they have
So
issued.
if that be so, my lord, there is hardly any scope to declare an award as non-verified. What is required to be verified? I could not follow. And nowhere has been indicated that these are the documents for want of which the award could not be verified. The title could not be verified. If my title is not been verified, then my name would not have been appear in the award sheet. Award has been declared in my name. My name is appearing. Apportionment has been done in terms of section 11, but
Section 30.
with the not section 30. They have not invoked even section 30. They have not referred to the civil court. Collector himself satisfied himself. That's why award has been declared upon due apportionment in compliance of section 11. But when the payment column, this has been said not verified. I will take to your lordship, my lord, to that part also. So therefore, my lord, kindly see. And compensation award was declared as not NV against petitioner respective share and area over the subject clause. No reason has been given. Relying on the statement made in the various subparagraphs of paragraph 3 of the APD, it is stated that the petitioner are in no manner prejudiced and their right is not affected in any manner whatsoever. But I could not follow. My right has been affected. According to you are published a notification under section 4. I cannot deal with the property since you have section 4 has been published and you are not paying compensation. So my right is not being affected.
Okay, next.
Next, my lord, kindly see. Then, my lord, kindly turn to the award.
They have annexed.
They have annexed in the affidavit.
Your name?
My lord, I am showing to you, lord.
Your name, Pradeep Kumar Jaiswal.
No, not my mother name, my lord. My mother name will your lordship. Earlier the petitioner
Okay,
Ramdulari Jaiswal.
there must be some Jaiswal.
Yes, Ramdulari Jaiswal at page 20.
At page 20, yes.
Lordship has got it. Serial number 182. Mouja Rai Gachi.
Yes.
And next. Again, my lord, your lordship will find 183. Mouja Rai Gachi. Plot number, my lord, 935.
Yes.
And here, my lord, the plot number is 3467. Now, my lord, kindly turn to section 4.1, which they have also annexed. In the, and one more thing is this, my lord, that the documents so annexed in support of their contention that award has been declared in my name. No date has been mentioned as to when this award has been declared. I shown to your lordship that one time they are saying that award declared, payment made. 2003. 2004 they are saying award is to be approved. So it is not clear in respect of which plot, in respect of which area, as to when the award has been declared. Not clear. That's why, my lord, the statutory mandate is that the intention of the legislature. If your lordship go through the statute, the collector shall make an award. There cannot be two sets of award in respect of one proceeding. That's why language is, my lord, the an award. But I shown to your lordship, my lord, here. First of all, two sets of award. and both the award was sought for approval, no approval has been accorded. So there cannot be any declaration of award. Then, my lord, lordship, kindly see one more interesting thing is this. In my reply, kindly see, my lord, at page 12 of the opposition.
Opposition again.
Opposition. The lordship got it.
Yes, page 12.
Page 12. My lord, this is the notification under section 4.
Hmm.
Your lordship will find on the last part, Mouja Gopalpur, plot number 3467.
Hmm.
Your lordship has got it. Then, my lord, kindly once again, kindly take a trouble to turn to page 20 once again.
Yes.
Kindly see, my lord. Mouja Raigachi, plot number 3467.
Hmm.
So therefore, in respect of this plot,
Plot number
3467,
20, page 20.
page 20, plot number
3467. Yes.
Mouja Raigachi,
Yes, yes.
but this has not been acquired. There is no plot number 3467 in Mouja Raigachi in the notification. On the contrary, what is in the notification? 3467, which is situated in Mouja Gopalpur.
No, 3437 area such and such, Sali within bracket Gopal.
Gopalpur.
Ah.
No, paragraph 12. Page 12.
You come to page 20.
20. Kindly see.
20, it is the award. Plot number 3467. It is RS plot.
Kindly see.
Now,
before that, Mouja
Sali Gopal.
No, Mouja Raigachi, jail number 12, plot number 3467. Gopal may indicate something else. Gopal does not indicate Mouja Gopalpur. There cannot be two sets of Mouja in a award in respect of the same plot, same plot. And in my lord, in the Raigachi, your lordship, before in that notification, your lordship will not find in the Raigachi any mention of plot number 3467. Before 3467 situated in plot Mouja Gopalpur. I am the owner of that land.
Come to page 14.
14.
Section 4 notification.
So this is section.
No,
6.
section 6.
This is section 6.
It is section 6 notification.
Yes.
Notification RS plot number in full 3467.
Yes. Gopalpur.
It is Mouja Gopalpur.
Mouja Gopalpur. So in respect of Mouja Gopalpur plot number 3467, no award till today.
And hence the situation demanded for rectification.
Now, when that can be rectified? There is a time limit, my lord. Kindly, who can rectify this thing?
Yes.
Because corrigendum is to be made in respect of section 6. This is not a rectification in respect of the award, because if it is a rectification required to be award, then my lord, kindly see section 13. When this can be done? Correction of clerical errors. The collector may at any time, but not later than 6 months from the date of the award. Can you see? So he cannot. Because, my lord, that's why I am saying there is no award even. No, my lord. This is another part of this thing is this, my lord, that they may take a plea that section 17 invoked. Therefore, in view of the ratio laid down by the UP Jal Nigam, that section 11 capital A has no manner of application. Well, this ratio has been dealt with by the Supreme Court in another judgment because and considered under which or what context the judgment was delivered in UP Jal Nigam and what is the ratio that is to be decided in the instant case, considering because the whole intention of the legislature is to pay just and fair compensation. I cannot be deprived. Now, UP Jal Nigam case, my lord, the state wanted to withdraw from the acquisition wherein possession was taken over by invoking section 17.
A land or vested.
Because the moment you have said and you have utilized, now you cannot revert back to your, or you cannot say, no, I will not take, I will not pay compensation. Where the Supreme Court has intervened. My lord, subject to your lordship correction. Yes. My lord, I understand, my lord, that this judgment is also there. This is reported in 2015-10 SCC 241.
Hmm.
তোমাকে সব বান্ডিল করে দিয়েছি আমি। কত হচ্ছে? 90 হচ্ছে। 101 আছে। আমার আছে।
Yes.
No, my lord. To this, I like to rely a judgment reported in 2015-10 SCC, page 241.
Hmm.
The same situation cropped up here. And Supreme Court said, judgment.
Oh, it was given. Okay.
Earlier I was given this.
Okay. Okay.
If it is not, my lord, then again.
Kindly citation, please.
2015-10 SCC.
Yes, got it.
Yes, yes.
Yes.
The same thing was cropped up because I tell your lordship why that it appears that section 6 was declared on 5th of June 2002.
Yes.
Now, in terms of section 11 capital A, the
3
award
years.
was to be made within 2 years from the date of publication of this notification.
Okay. 2 years. Yes.
So, my lord, 5th of June, 4th of June 2004.
Hmm.
I shown to your lordship, in the month of September 2004, they are asking for approval of the appropriate government for the purpose of declaration of the award. Kindly see, my lord, once again the order sheet. I shown to you 8th of September 2004.
Hmm. So your case is that although they in their notification they refer the section 17(4), but actually they have they didn't invoke the same.
Did not.
Ah.
Condition precedent for invoking 17(1) has not been complied with even.
Comply with
Even in the order sheet,
17.3, no 80% payment of
nothing,
the
nothing,
land
nothing.
has not been offered. Land has not been taken possession also. Possession has not been taken. Now,
So in fact, if they can wait till the declaration of the award for the purpose of taking over possession, then there was no urgency. 17.1 provides for urgency. Now you waited for declaration after section 4, section 6, and waited for declaration of the award. Then presumption is not allowed the moment they are, according to them, they have categorically stated in the affidavit that after declaration of the award, possession taken over. Now, whether this is a symbolic one, I am supported by a judgment, my lord. Symbolic possession won't do. It's a certificate of possession. There was no physical possession they have taken over. Because till, my lord, I am paying the electricity bill in respect of that of my area, of my land. Now, my lord,
what was the purpose for acquiring the land? For the
according to
purpose
them, my lord,
acquisition
this
of
is
the land
my lord, according to them,
Oh, new town, establishment of the new town, Calcutta.
or new town? Okay.
there is no end.
Huh?
There is no end of the project.
Yes, certainly.
Everything is under the new town.
Certainly.
Okay.
You are paying 10 rupees and you are earning 100 rupees. Anyway, chalo.
Okay. Next.
Next. Then, my lord, দাঁড়াও না। আরে এটা দেখবো তো আমি কি দিয়েছি। আমি পড়িনি না, আমরা কি করব?
Yes.
Now, my lord, kindly see. Kindly see, my lord. At that subsection 3 of section 17.
I have seen subsection 3.
So there is no
80%. 80%.
There
Yes.
is no complaints.
They have not offered 80% of the.
And nowhere in the affidavit
Right.
they have said they have taken over the possession by invoking section 17. Nowhere in the affidavit they have said. On the contrary, my lord, they have in the affidavit they have said that possession taken over after declaration of award. এটা দে তো যেটা
17.1 permitted the collector to take possession on expiration of 15 days from the publication of the notice under section 9. But section 3A says before taking such possession, collector shall, without prejudice to subsection 3, tender payment of 80%.
Now, my lord, I am grateful to your lordship.
Hmm.
Now, kindly have a look at the, my lord, the notice dated section 9 at page 21. At page 21 of my writ petition.
Yes, so 21A. 21A.
21.
The type copy 21A.
21A.
Yes.
Kindly have a look at the, my lord, the date when this was issued.
9/8/2022.
9/8/2022. Now, kindly have a look at the, my lord, the section 4 notification when this was published. 24th of April 2022. 2002. 24th of April 2002.
It is.
That doesn't mean that after expiry of issuance of notice under section 9. So this has not been issued in terms of the mandate of section 17.1. Because you have to serve notice section 9 indicating, look, we are going to take over the possession, you have to vacate it. After expiry of 15 days, so that I can shift or I can accommodate within 15 days to elsewhere. then only section 4 followed by section 6. Here, my lord, before that, section 4, section 6, then section 9. Usual manner. That is the usual course of process of acquisition. Section 4, objection, section 6. Here, my lord, why this has been done? Only intention is to, so that I cannot raise my voice. I cannot protest it to the acquisition. So giving go by to the statute,
Right under
under
5A,
section 5A.
they have snatched away, right?
So just go by to that provision, my lord. Only a mere writing section 17 has been 17.4 has been invoked. No compliance of section 17, the subsection 3 of section 17, non-compliance of section 17.1. Moreover, I shown to your lordship, my lord, nowhere in the order sheet that has been produced before this court, nowhere this has been indicated. Whatever award that has been passed, that has been approved.
And 5A objection is not after 6. 5A objection is after 4.
So that is exactly what
Objection,
I have said.
That is not the.
That is exactly what I have said.
My lord,
Since-
your lordship said that, my lord, to grab the land, my lord, and to give him not to,
Any hearing under section 5A.
after section 4, my lord, that 5A is, my lord, invoked. So, my lord, there is any,
My lord,
that,
my lord, possibly,
category
my
is
lord,
not.
Mr. Day is not with the brief.
Yes, my lord, today I am.
So that's why he is
As because
submitting
my-
with this.
Today is not with the.
No, my lord, because section 4 notification says that section 17.1 has been invoked. So I cannot. And in the section 17 section 4 notification, this has been categorically mentioned
Lord, I must-
that objection
my lord,
under section 5A
But I must
is been waived.
submit yes, my lord, after what, my lord, after some time, my lord, my learned friend wants to say, my lord, according to the provision, section after section 4, 5A is, my lord, introduced. Not after 6, here,
Not
4,
said so.
6 and other.
Yes.
No, I'm not. তোমাকে এটা বলে দিলাম, my lord,
But if you invoke section 17.1,
then my lord, all the provisions of that are.
yeah,
uh,
51A will go, and when that's the limitation section 6 or anything like,
in another.
section 6, limitation of section 6 or,
11, capital 11, 1 year.
17.
Section 4 to section 6, 1 year.
That is the,
Section 6 to section 4 to section 6 is 1 year.
that is, I will not want to.
no, there is another liberty to issue section 6 notice, come to section 4, yes.
1 year.
If it's so direct declaration may be made under section 6 in respect of the land at any time after the publication of the notification under section 4. Another clause is there. Yes.
My lord, what is the prescribed mode? Because if your lordship kindly see in the order sheet, before section 4, they sought for approval of section 4. In that approval, there is no indication of section 17. Because my way of understanding of the law is this. If statute prescribes that after expiry of section 17.1, 15 days from after expiry of issuance of notice under section 9, you can invoke under section 17. So there is hardly any scope to publish this section 17 along with section 4. Hardly any scope. Because kindly see, my lord, the section 17 is an independent one. Section 17 is an independent one. Kindly have a look at the, my lord, the section 17 ones. Can you see section 17? Such lands.
No, yeah, where the state has been given liberty to ignore the sections 4 and 6. Where?
In the, my lord, no, section 4 and 6. No, there cannot be
Now,
ignored.
if they invoke section 17,
Yes,
one,
in the notification they have said so. Because I tell you, lordship,
oh, you are saying that section 17 is an independent provision.
I tell you, lordship,
And there is meaning thereby there was no requirement of issuance of section 4 notice.
section 4 notice prior to invocation of this. When this can be done? After issuance of notice under section 9, 15 days expire, invocation. Section 17. And property vested with the state. Now, section 4, why this is section 4 is required? My way of understanding is this, my lord. In absence of issuance of section 4, my lord, there cannot be determination of market value. Because determination of market value, the cutoff date is the date of issuance of notice under section 4.
4, yes.
That's why section 4 is required. Today, you have invoked section 17 for the purpose of taking over the possession property vested with the state. Market value will not be from that day. Market value will be the date when you publish the notice under section 4.
Yes.
You can publish after 2 years. But before section 17, mandatory provision is this, my lord, you have to serve notice under section 9. I shown to your lordship, my lord, that section 9 was served later on. And there is also, my lord, when section 17 can be invoked, where is the urgency that has been described in subsection 2? The mode of urgency. Mode of urgency has been described in the subsection 2. That why this is required. Can you see? Whenever going to the sudden change in the channel of any negative river or other.
It is different. It is different.
No, section 7, because you have to-
Section 2 is different.
Yes, because
For the purpose of construction, railway, bridge, such and
yes,
such.
yes. So there
But
is
section here in cases of urgency, other than enumerated in section.
Yes. Then, my lord, the condition precedent is prescribed in subsection 3.
Yes, subsection 3A.
Tender payment. Collector shall. It's a mandatory.
Yes.
And moreover, my lord, kindly once again, my way of reading is this, my lord, that section 4 notification. Kindly have a look at the section 4 notification, my lord. In exercise of the power, that at page, my lord, 17, at page 17. No, my lord, repetition, the notification.
Oh. Yes.
In exercise of the powers conferred by the subsection 4 or 17(4) of the Land Acquisition Act, the governor is pleased to direct that the provisions of section 5A of the Act shall not apply to the lands as described, shall not apply to the lands as described in the schedule below, to which, in the opinion of the governor, the provisions of subsection 1 of 17 of the said act are applicable. My understanding of this language is this, my lord. This has not been invoked. It is applicable. For the purpose of applicability, my lord, of this provision, you have to comply section 9. You have to serve notice. So these are the two lines that has been written over here. It's a proper non-application of mind. In effect, this has not been invoked. Because why I am saying this, my lord, in support of my judgment.
Yes.
So therefore, my lord, in this proceeding, the alleged award is honest in the eye of law. And in view of 711 capital A, the entire proceedings lapsed. Entire proceedings. Now, if they want to acquire my land, they have to initiate a fresh proceeding under the 2013 Act.
13 Act.
20, there is no other way. And moreover, my lord, the records, it appears from the record itself that no award has been declared. Award in terms of section 11, specifically in terms proviso to the section 11, which is mandatory in nature.
Yes. That's all?
That's all. And my lord, if my learned friends submit any other judgment, my lord, then I will.
Yes, yes.
My lord, first it comes
Uh,
from time, my lord, as because I am not with the file, my lord. My lord,
only this question, that whether in absence of approval from appropriate government, whether entire proceedings which lapsed and award.
yes, my lord, all the matter was heard and but so my lord, that matter is my lord is under. So my lord, I must take some time, my lord. My learned friend, if wants to say something,
Lordship,
the recurring he can say.
You are in possession.
বলে না বল
I am very sorry, my lord. Before I conclude,
যা দেখাবার দেখাও
before I conclude, my lord, kindly keep two affidavits side by side. One filed by the requiring body and one by the state. Kindly keep side by side.
Tell what?
Yes.
What are the animal?
Yes. In paragraph 20, in the state affidavit, in paragraph 20, they have annexed the award. Award sheet. In serial number 182, the name of my mother is appearing. Wherefrom it will be evident that Mouja Raigachi plot number 3467. But the affidavit filed by the requiring body,
Yes.
the same document there has been annexed and the same serial number, but manipulated the moment because after filing my reply to this affidavit of the state, requiring body filed this affidavit, their affidavit. Now they tried to correct that mistake by manipulating that one. What they did, they have struck down the Raigachi, written Gopalpur. I shown to your lordship that cannot be done if any correction is made to be made. That is to be done within 6 months from the date of declaration of the award.
In accordance with 13A.
According to 13A. So this has been manipulated by the requiring body himself.
Okay.
It is not by the collector.
Okay. Whether will you conclude?
No, I will not conclude, lordships. Today, lordship, my learned friend on behalf of the state.
So your is complete denial of any manipulation, and now you are in possession.
Lordship, my responsible submission is this. The acquisition proceeding was initiated in the year 2002. And writ petition was filed in the year 2016. After 14 years.
Yes.
After 40, may I take your lordship's leave, my lord? Another matter may be called.
Yes.
After 14 years. So the writ petition itself is a stale proceedings. And lordship, over this issue, lordships, the famous judgment of apex court lordships, after considering 442 judgments of apex court, that is Indoor Development Authority. 2028 SCC, volume 8 SCC. And lordships, here lordships,
8 SCC page?
column 8, page entire book lordships. I am placing the book. দিন না
এই দিন
copy. I one copy of I was not prepared from the same lordship rest.
had 5 years or more.
Five.
The Honorable Court did not entertain.
Not entertain lordship.
Hmm.
They stated that belated proceeding is nothing but a laches, and this laches is enough for dismissing the writ application, rejecting the writ application, whatever may be the question. All such questions arose before the Honorable Apex Court. After considering all such questions, the judgment has come out, lordships. Lordship, relying this judgment, our court also passed judgment, several judgment, lordship. I also bring such judgment, lordship. One paragraph, lordships, here, lordships. There is upland tomb case, lordship. I have no second.
Yes, got it. You can take it.
I'll show one paragraph.
Yes, yes.
I think, lordship, after this judgment, lordship, thing is required. I could consider the contention, lordship, I am reading from this judgment, lordship.
Paragraph.
Paragraph 350.
Okay, 315, yes.
Paragraph 350 of the judgment, lordship. I am reading the High Court considered the contention of the appellant that the award in respect of the compensation was not award in the eye of the law, though the possession was taken long back and the railway has been laid out, the acquisition proceeding was liable to be set aside, the compensation liable to be re-awarded and the present market rates. The High Court rejected the said plea by judgment such and such. In Jasbir versus UP in the year 2008, it was observed that the objection of the appellant against the award has already been considered and remanded to the Supreme Court in the year 2005, lordship, was only in respect of the statutory benefit. For the first time, that plea, lordship, in the upland tomb case, lordship, and Swastika versus such and such, and Bangla versus such and such, the judgment of the Royal Orchid versus Joysamon Reddy was distinguished and it was related such and such. Taking into consideration the entire facts and circumstances of the case, we are of the view that the writ petition is highly barred by laches and deserve to be dismissed on the ground of laches alone. There are catching up decision here, lordships. I am after Mr. Dev.
Yes.
Completion of this argument, lordship. I will place this thing to add some fuel to the fire.
Okay. Oh, yes.
Alert 29, your lordship fix the matter at 2. Next.
Two most probably at 2 p.m. all. কবে লাস্ট 2 p.m. ফাঁকা দেবো কবে? কতগুলো আছে? কম 2 p.m. যেটা আছে সেটা না 29 চাইছে না, তাহলে
নেক্সট
পরের সপ্তাহে দেবো।
কবে? 30? তো 30th 30th করে দিন। আচ্ছা, হার দ্য লার্নেড অ্যাডভোকেট অ্যাপিয়ারিং ফর দ্য আপনি করুন তো।
With your lordship leave.
Before I am for the state respondent, I want to file affidavit in opposition in this matter. Although matter is 2018, my lord, I am recently engaged in this matter. My lord, affidavit is very much required.
Who is the other side? Other side is Mr. Bari. So Mr. Bari, they are seeking leave to file. Whether this direction was given earlier or not,
My lord, I do
for
not
the
know.
first time.
It is the last time.
It was given. Yes, it was given.
Was given the respondent number 6.
So today you will go leave the court. Tomorrow. Okay. Okay. Okay, not today. Yes.
Respondent number 6 filed an affidavit of opposition. The reply have filed only they can take in instruction. I was taking regularization in terms of their own case. This is the third point which is involved, and I cited the certain judgments of the matter, but your lordships must be
Give them a short time.
My lord, I am appearing for the my lord, I am appearing for the other respondents. My lord, I have filed affidavit. But my lord, last
Yes,
occasion,
yes.
yes, my lord, last occasion when the
Now
matter was taken up, my lord,
state is seeking extension of time to file their affidavit.
my lord, that may be given, my lord. That may be
My
given,
lord,
my lord.
State is the authority to my lord, finance the corporation.
Yes. We'll give you salaries, the state. Huh? So a limited period.
My lord, 4 weeks.
For it.
It will be better. After 2018, getting chance. He's praying for 4 weeks, let it be 40 weeks. Another 40 weeks we can. What is going on? The state is
7 years.
State is in spite of repeated direction, they have chosen not to file an
No, my lord, earlier
Oh, it is of 18.
Yes, but I have initially I have stated.
Time.
My lord, earlier another advocate was engaged. My lord, he has not nothing done.
That is not the excuse. Another lawyers, another change, another.
My lord, let them pass an expertise order.
Yes.
No, no, place this matter. If not necessary, your lordship may pass the
On the
expedient.
basis of the, why expert? You are appearing here. Expert means.
I am not appear.
Then don't appear.
Without granting any time for affidavit in opposition, I am not appear.
Mr. Haldar, don't get angry. 7 years, the last
Yes,
opportunity
but I have initially I have stated it is although
took time. Look,
2018.
on 10th August 2018, on your prayer, date was given 4 weeks. Time was fixed for 4 weeks to enable you to file the affidavit in opposition.
My lord, 2 weeks time may be
7
given as a
years
last
ago.
chance, my lord. My lord, 2 weeks time, 2 weeks.
7 years.
I am not denying, my lord. That's why I initially
The
I have
child who was
stated.
born on that date now is
It is not only
attending
4 weeks,
school.
my lord. 7 years is waiting. Only 4 weeks.
I can
my
wait
lord,
for 7 years.
my lord, I only
for 7 years.
4 weeks. 4 weeks. It is not.
My lord, some time may be given as a last chance, my lord.
You have filed your affidavit in opposition reply. It is not your turn. Yes, fine. He said only said it is for the state policy.
Too short a time, my lord, eventually, my lord, again coming and praying for that. So sometime I will give whatever your lordship feels appropriate, or kindly give us that time.
Let them pay cost.
As a last chance, some time may be given, my lord.
No, you have filed an affidavit. Why is the time should be given to you?
No, আমারটা বলছি না বাড়ি স্যার, আমারটা বলছি না।
File an
বাড়িতে
reply.
আমারটা বলছি না,
He
stated
is supporting the state to some extent. He knows where from his fees is
My
coming.
lord, the corporation
We are from
without
every side.
finance,
I tell
finance
you,
from the
Yes, yes,
state.
I
Without finance from the state.
every day we are facing the trouble before our client. 18 years a person, my lord, 2018. Today, my lord, we are doing this case from 2009, 2010, 2011. 2018 matters, the 4 weeks time was given. They did not have any time to file an affidavit of opposition. Your lordships heard the matter. They have chosen not to appear before your lordships. Again, I have served the notice pursuant to your lordship's direction. Today, they are coming and seeking for direction. Let them produce the record. On the basis of the record, your lordships can dispose of the matter. Either this way, that way.
We'll produce record. What records? We don't have any records. These are not our employees. These are casual employees, my lord, whose remunerations
All a
are thought to be
contract,
imposed upon the state.
all a contractual
Yes,
appointment has been made
Contractual
for a
appointment
limit.
on-
Whatever that is depend upon the merit, that you are all going to merit,
We're
but
paying for some
But
time, my lord.
this thing that the state and many other authority, respondent authority, taking time from the court, they are not filing affidavit years after years.
Unfortunately, it is a
In one matter, most probably DBC, I expressed their mind that in that circumstances, court will be forced to hold that the respondent has nothing to say in this matter, or he is not unable to controvert the averment made in the writ petition. And hence the averment of made in the writ petition is accepted and accordingly disposed of by passing the order or giving relief as has been sought.
we are
Nothing can be done.
Everybody,
Years after.
That's this correct. But if
Yes,
it is
after.
not to say
everybody is
anything,
blaming to the court. Matter is not-
Legislature has given a power to the discretion to the court to treat this, to take a adverse inference against the respondent. If the averment is not properly dealt
yes,
with
absolutely. Your lordship, it is
and controverted,
yes.
that means you are unable to controvert
Yes.
the averment. 1 week.
One week it is-
Our agony, my lord, being
It is not-
expressed throughout the client's agony is being expressed to us.
Okay, as a last touch, Mr. Haldar, learned advocate. May. It will appear in my court on that day.
Yes, sir,
And don't that it will.
I'm much obliged, my lord.
On 15 day. 15 May.
Act two.
Grateful one.
Act 2.
The two-
Okay, Act 2. Yeah. Yes, next.
Grateful, my lord.
Yes. এই ওনার নামটাও লিখে দেবেন। ওনার ইয়েটা, হ্যাঁ।
Thank you.
Next. হ্যাঁ? হ্যাঁ? হ্যাঁ। এই দুটো ওদের একটা কাগজ হচ্ছে দেবেন। এই দুটো থাক না, রেফার করা হয়েছে তো। ওকে বলুন জেরক্স করে দিতে, এইগুলোতে রেফার করা হয়েছে, জেরক্স করে দিয়ে দেবো।
In the next matter, my lord, I am for the state respondents.
হ্যাঁ,
My lord,
will pay for time for
extension for 2 weeks.
you are for the petitioner.
Yes. For 2 weeks, my lord. Only. And last chance, my lord, I shall come with the affidavit because affidavit is necessary, my lord.
হ্যাঁ,
Affidavit is necessary.
কি করা যায়?
As the last chance.
Said
I am
the
praying.
court, all claims upon the court, the matter lakhs of 77 lakhs
Oh.
possibly pending. So this is the fault of the court. This is the, my lord, kindly see the
Yes,
cooperation.
no.
No, I'm not blaming
That
you.
I can. No. Every.
The state is doing this one.
ওকে সেম অর্ডার লিখে দিন, ওনার নামটা ওই মিস্টার হালদার ওই সাচান সাহেব লিখেছেন অ্যালং উইথ মিস্টার চ্যাটার্জি ওনার জায়গায়।
File is being.
My lord,
rejected
my lord.
after 19 days delay, the lordship considered the matter.
My lord, one thing, may I, my lord, in this, my lord,
And detail, batches, comments, everything has been put.
Yes, yes.
my lord, one,
My kind of facts.
my lord, regarding,
I have got your point.
my lord,
Yeah.
regarding, my lord,
In case of delay, Mr. Saha will come.
Yeah.
my lord,
If
I
you
said-
cause delay,
my lord,
such and such,
to any delay.
no sufficient
Yes.
explanation, nothing,
My lord,
it has
my lord,
not,
my
it
lord.
is not acceptable, then you will come.
My lord.
And you will not file affidavit in reply or affidavit for 7 years, 10 years.
No, no.
Everybody appreciates your.
But as a last chance, special chance.
No,
Eh?
the last chance. My lord, one thing, my lord, may I submit before your lordship, in this matter, whether, my lord, kindly clarify that whether Panchayat authority, my lord,
Take all this point, affidavit, you'll definitely.
no, no, no,
Yes,
let
yes.
them come, whether notice has been served upon the Panchayat authorities, the respondent number,
Time নিচ্ছ কেন?
ঠিক আছে, no, no, I shall file my affidavit. That is not there. But Panchayat, the presence of Panchayat authority is necessary. Let them direct to serve a notice upon the Panchayat authorities. That is the,
If they choose not to come, let him file affidavit.
I shall file. No problem.
Okay, next.
Give your lordship.
এই 32 not today হলো তো 32 ও 38 আচ্ছা 38 yes. Coal India, who is your other side? They have not come. That matter.
They are not coming, my lord. Here, my lord, the cost was imposed for filing, for delay in filing affidavit in opposition. Neither the cost has come nor the affidavit in opposition. Last time your lordship accommodated them as a last chance. It has last chance has also gone. Before that, without, in their absence, matter will be heard, that has also gone. The matter was once parted
Oh.
by a coordinate bench, but for change of determination, the matter was released. Now it's before your lordship.
Okay, you place.
But the disciplinary proceeding has culminated in an order of censure. Disciplinary proceeding,
Censure.
yes, censure.
Yeah.
Now, that is under challenge in this petition. If your lordship, my lord, I just hurriedly take your lordship through the, my lord, the relevant, my lord, the charge sheet, the inquiry report. The charge sheet is that page, kindly have a look. It's a disciplinary proceeding, so I have to, my lord, place the whole thing, otherwise. My lord, the articles
Yes.
of charge, I take your lordship to page 31
Of the petition.
of the writ petition.
Yes.
Page 31 is the articles of charge. The Subodh Kumar, while posted and functioning as senior manager mining, Rajarappa area, during the year 2012 to 2016, committed gross irregularities in matters of submitting property return and intimating the competent authority about acquisition of immovable property. Inasmuch as even though he was penalized for non-submission of property return in the past, he advertently suppressed the fact of acquisition and possession of shop numbers 201, 242 and 243 at Bokaro Mall, Bokaro, Jharkhand, in the name of his wife, Srimati Monika Singh, from the competent authority and did not intimate about the same. Then, thus, Sri Subodh Kumar violated Rule 19.2 of Coal India Disciplinary Appeal Rules applicable to him and acted in a manner unbecoming of a public servant. Then, that during the, this is Article 1, then, that during the aforesaid period and while posted in aforesaid office, Sri Subodh Kumar committed further gross irregularity in the matters of reporting to the competent authority about his engagement in a private business trade, inasmuch as he advertently failed to inform the competent authority about the business dealings done by him with different businesses, agencies, and thus grossly violated Rule 16.1, 16.2 of the rules. Thus, Sri Subodh Kumar violated Rule 16.1 and 16.2 of the Coal India Executive Conduct Discipline Appeal Rules applicable to him and acted in a manner unbecoming of a public servant. Hence the charge. Now, my lord, this is not still, this is the charge. Now, my lord, I take your lordship to the fine. I denied the charges. Then an inquiry was commenced, and kindly have a look to the inquiry report at page 46. I start at page 45 at the bottom.
Start from?
Page 45 at the bottom.
Yes.
Page 45. This is the concluding
Finding.
part of the inquiry report. 4. Finding of the inquiry. In view of the facts discussed above and on the basis of assessment of the evidence forming part of the records of inquiry, management brief and carefully perusing the defense brief reply advanced by Sri Subodh Kumar with application of my fair mind, I have come to a conclusion that the charged officer has violated provision of Rule 19.2 Disciplinary Appeal Rules inasmuch as he failed to comply them for the process of acquisition of shops numbers 201, 242 and 243 at Bokaro Mall, Bokaro, and thus the charges as constituted in Article 1 of the memorandum is substantiated and established. Now, my lord, this, my lord, here, my lord, I just pausing here. My lord, this part of the finding for the process of acquisition of shops 201, 242 and 243 at Bokaro Mall is a new charge imported by inquiry officer while coming to a finding. I'll come to that one after the other. This is one of the informatives that I thought I should point out at the relevant point. Kindly next page, 46. For the reasons as explained above is in factual analysis, I do not consider the charges as contained in Article 2 of the aforesaid memorandum regarding directly or indirectly associated into any trade or business and violation of Rule 16.1, 16.2 is established during the inquiry, and thus Sri Subodh Kumar so and so, then senior manager mining, is guilty to the extent of the part Article 1 of the substantiated charges only. Meaning thereby charges Article 2 is not proved and article of charge is partly proved. So this is the finding of the inquiry officer. It goes to the disciplinary authority. Disciplinary authority disagrees and passes the order at page 47.
Yes.
This is the final order of the disciplinary authority. 10th of May 2022. I just showed to your lordship the relevant portions. My lord, the
Reduction to 2 stage.
Yes.
Lower. Yes.
yes,
Reduction of space.
2 stages
scale.
lower in time scale of pay
Of
for a
pay.
period of 6 months from the date of
If preferred appeal,
yes,
appeal
appellate
court
authority
reduce the punishment.
to a punishment of censure,
Yes,
from major
yes,
punishment to minor punishment.
Yes, censor, yes.
Against that, I prefer an appeal.
Huh.
Then appellate authority, lordship kindly have a look. I just appeal against DS order. Appellate authority kindly have a look to page 75.
75, yes. 75.
My lord, if your lordship, my lord, goes through this order of the appellate authority, my lord, or in my humble submission, the penalty of censure is also not called for.
Payment.
Is not censure, but am I not audible to your lordship? My lord?
Yes, yes.
My lord, the penalty of censure is also not called for in the facts of the present case because of the findings of the appellate authority himself. Lordship, kindly have a look to page. I just placed a few of it. Kindly have a look to page 72, the appellate authority's order.
Yes.
My lord, I just want to place these 2 pages because that will, I think, my lord, towards the middle, whereas Subodh Kumar prepared an appeal dated 18th of May 2022, lordship got it towards the middle of page 72. Then,
72.
whereas on perusal of appeal preferred by Sri Subodh Kumar, along with the case file and documents on record, the following has been observed by the appellate authority. Sri Subodh Kumar contended that verification report, a basic document, has been denied to him so as to deny him reasonable opportunity to defend his case during inquiry, which is in violation of such and such. IA has influenced to establish the charges in Article 1. The charges under Article 2 were not proved, even though DA gave dissent note to establish the charges and imposed the penalty without considering the representation against the dissent note. Video order dated 10th of May 2022. This is the final order of the disciplinary authority. The dissent note itself, DA clearly mentioned that though actual or direct involvement of Sri Subodh Kumar in business may not be evident, indirect involvement is substantially proved. Then this finding ought to have been resulted in his exoneration. This is the view or the finding of the appellate authority. Why I am placing? Because these findings do not invite even the minor penalty of censure. And for this minor penalty, he has lost 3 chances of promotion to E8 grade. That is a GM level. Lordship kindly sees, and the last one has gone just 19th of this month. But because of the pendency of this case and the order of punishment of censure, he is being denied the promotion and he has lost 3 chances, substantially prejudicing his service career. Now, Lordship kindly sees, I just placed it because this will then, I was placing this part. This finding ought to have resulted in his exoneration from the charges, but he was imposed major penalty without any evidences. Instead of proving the charges by evidences of prosecution, shifted the burden on him to disprove the charge, which is unfair, illegal, and unethical. Then, it is undesirable, next paragraph, to hand over the verification report of Vigilance Department at the time of inquiry. Srimati Monica Singh had entered into the contract in purchase of properties. Monica Singh is the wife of the petitioner. Purchase of properties from Mrs. Amit Realty from her known source of income. It is irrelevant to the appellant to give prior intimation to purchase immovable property. As per 19.2 CDA rule of CIL, purchase of property by spouse from known source of income need not necessarily to inform the transaction to the company. However, he has intimated the purchase of property and informed through Form 4A the contention of the appellant has some merit. This is my content. The other findings of the appellate authority. Then B. The Subodh Kumar further contended that TA fell into grave error in holding when the facts are established in the form of documents, no amount of oral evidence is required to prove it. Next page 73. This is an erroneous and illegal finding of the TA. For the simple reason that facts are never established in the form of documents, and oral evidence of the authors of the documents can only prove and establish the contents of the documents and not otherwise. Your Lordship knows the well-known principle that author of the document must come and say, yes, this is my document, I wrote this letter, I signed my document.
Evidence must be direct.
Yes. TA held illegally that the copy of agreement and the emails are enough documented evidence to prove that he had acquired the shops for the purpose of indulging in business in the name of his wife without prior intimation to the competent authority. Neither the agreement nor the emails relied upon were proved by the management in the inquiry proceedings. The finding of the DA that the aspect of acquisition of property is conclusively established through the agreement to let out the shop number 201, his contention that the builder with whom his wife made the agreement was not examined so as to ascertain whether shops had been acquired by him or not. Making advance payment of property is different from acquiring a property, and as per accounting principle, these payments come under movable assets and not required to intimate the competent authority, as even after making payments, the deal fails. IA as well as the DA have not considered the most relevant material that the title of the shops was in dispute, although such title to the shop was never passed on to his wife, Monica Singh, under the transfer of property in any manner, and consequently, there has been no acquisition of shop by his wife. As such, there was no question of giving prior intimation to the
competent authority regarding the same as required under Rule 19.2 of the CDA rules. Well, it's cart before the bull. Property was not acquired by the wife, but the charge sheet mentions that you acquired the property that never happened. Lordship kindly sees the decision-making process, how he has been treated, this gentleman, by the authorities. Lordship kindly sees. Then, that's why, I just read once again. Title to the shop owner was never passed on to his wife, Monica Singh, under the transfer of property in any manner. And consequently, there has been no acquisition of shop by his wife. As such, there was no question of giving prior intimation to the competent authority regarding the same as required under Rule 19.2. Could not differentiate between the advance payments. DA could not differentiate between the advance payments made by him, seeking acquisition, and actual acquisition made by him. So specific finding. Then name and mobile number mentioned in the email are not enough to prove his involvement in business dealing with the firms. The name of Sri Subodh Kumar, the petitioner, and his mobile number contained in emails of Messrs. Congas Food Service Equipment Private Limited and Alta Pure Technologies and Appliances has not specified any monetary involvement received, paid through him. Mere mentioning the name in the emails, holding him doing private business without intimation to the company does not hold good. Any evidence, either oral or documentary, that he had monetary consideration for the firms or he made payment for any purchase of materials, services rendered by him to prove the charges. As per Rule 16.1 and 16.2, he should be engaged in private business dealing with any firm. No evidence was supported that he was engaged in private business with Messrs. Ganesha Jadhav, ex-foreman. He is no more now. In the agreement made between Srimati Monica Singh with the said foreman, because the property was handed over to Mrs. Monica Singh on 3rd of June 2021. Lordship, this is very vital. The property was handed over to Mrs. Monica Singh, the wife of the petitioner, on 30th of June 2021, after issuance of the memorandum. So, the charge sheet contains the charge of acquisition of property by my wife, but the property was handed over to Monica Singh on 3rd of June 2021, whereas the charge sheet was issued to the petitioner alleging that my wife acquired property. Charge sheet was issued on 25th of May 2021. So doing private business by Sri Subodh Kumar does not hold good. Then
Yes.
Then I just place this because this is very vital. Then C, Subodh Kumar further contended that DA, this is my contention in the appeal, failed to appreciate that though the emails of Mrs. Congas Food Technology and Appliances were relied on by the management, but they were never proved. In this case also, DA shifted this burden upon him to prove the negative, which is impermissible. This was my contention in the appeal, one of the grounds of appeal. This is one of the then the Lordship kindly says, DA has consciously overlooked that there has been no acquisition of any immovable property by him. IA brought a new charge of disposal of the property by the appellant, as he has no authority to frame any new charge. In the order of DA dated 10th of May 2022, a new charge of indirect engagement in private trade in the name of his wife, and therefore Rule 16.1, 16.2 were clearly attracted without any evidence. Even he was not given an opportunity to defend it. A new charge was brought by the disciplinary authority, and no opportunity was given to the petitioner to deal with or deny the same. Then the finding in italics are the findings of the appellate authority. In italics, contention of Subodh Kumar has some merit because the charges should be proved through conclusive evidence. The name and mobile number contained in the emails of Messrs. Congas Food Services Equipment Private Limited and Appliances were not properly examined in the inquiry.
it is also true that new charges were invariably incorporated in the IS report. This is the finding of the appellate authority, as well as the order of penalty. So both IA and DA incorporate new charges which were not there in the charge sheet itself.
That's it.
And that's the appellate authority holds that. Yes. Yes, it is also true. This is the finding of the appellate authority. And then IS report has also no opportunity was not no was it is twice.
Given to
No
defend
opportunity
such.
was given to defend such charges.
That's right.
This is the finding of the appellate authority. Then I'm omitting the next page, first paragraph. Lordship kindly comes to the second paragraph.
Yes.
Contention of Sri Subodh Kumar has some merit because he intended to purchase a new property, shop number so and so, at Bokaro Mall, so and so respectively, but the title of the property was transferred on 3rd of June 2021. It was not possible to intimate the transaction to competent authority without any base documents. All the transactions were completed on 3rd of June 2021. Even there is dispute in acquisition of the property. The charges mentioned in the present memorandum have no relevance with the penalty imposed for submitting APR not in time. The clear findings of the appellate authority. Then, and whereas, Lordship kindly sees, this is very vital, I will come to this. Whereas in bold letters, CMD CIL appellate authority, after analyzing, but the appellate authority then is CMD CIL, because I am in E7 grade. After analyzing the relevant case files and documents, including the memorandum dated such and such, written from defense such and such, and other documents on records on the case, observed that one shop, Unit 201, was booked in 2010, and second one, Unit 243, was booked in 2014 at Bokaro Mall. But the title, this is very wide, title to the properties were not transferred, was transferred only on 3rd of June 2021. It is further observed that immediately after acquisition, he submitted Form 4A for giving intimation. For giving intimation for transaction in respect of immovable property on 8th of June 2021. As per records, Sri Kumar paid large sum of money from his own bank account during the year 2016 to acquire the shops in the name of his wife. Besides this, he was signatory to the agreement dated 19th of May 2020.
But you have not given prior intimation.
Yes, that's the charge. The appellate authority, that was not required because the property was not transferred in the name of my wife. But the charge sheet says that my wife, how can, well, this is something then Ramayana was Ram was not born then. The property was transferred long after the issuance of charge sheet. So how the charge sheet could contain, I am putting the question to myself, a charge of not intimating acquisition of property by my wife, that there could be no charge. Dorsu kindly says thereafter. This is when the observations are very clear. Was booked on, it is further observed, but the title to the property was transferred only on 3rd of June 2021. Yes. It is further observed that immediately after acquisition, he submitted Form 4A for giving intimation for transaction in respect of immovable property on 8th of June 2021. As per records, Sri Kumar paid large sum of money from his own bank account during the year 2016 to acquire the shops in the name of his wife. Well, the loan has been given by the husband to the wife, and that can be done. It's tax-paid money, it's earned money. So what wrong he has, if he has done so, what wrong he has committed? And also, besides this, he was signatory to the agreement dated 19th of May 2015 between one Ganesh Yadav and his wife, Srimati Monica Singh, to let out the shop numbers 2 and 201. He entered into a series of financial, I'm not reading that. Then,
that part, yes.
So, Sri Kumar gave intimation to the management after acquisition of the management, after the acquisition of the properties. The fact remains that he did not send any intimation to the management
till the date of issuance of the memorandum of charges. This is a clear contradiction. Earlier said that the acquisition property of property takes place after the issuance of charge sheet. Now here it says, Lordship kindly says non-application of mind, complete non-application of mind. So Sri Kumar gave intimation to the management after acquisition to the management after the acquisition of the properties. The fact remains that he did not send an intimation to the management till the date of issuance of the memorandum of charge. How it could be? Inconsistent observation. This part is faulty in my humble submission. The appellant should have been more careful as he was inflicted a minor penalty of censure in 2018 for his failure to submit his annual property return. Now pausing here for a moment. My lord, in 2008,
Yes.
2008, he was fastened with an order of censure. That is also my lord, mentioned in the charge sheet. But then I'll come to that. However, there are no conclusive evidences regarding the indulgence of Sri Subodh Kumar in private business in the name of his wife, and the same was also not provided in the inquiry. Not provided, should be proved in the inquiry, should be proved. Then, considering the above facts and circumstances of the case, it is felt that a lenient view may be taken in respect of Sri Subodh Kumar. Therefore, it is decided to moderate the penalty imposed on Sri Kumar from reduction to 2 stages lower in the time scale of pay for a period of 6 months from the date of issuance of his order. This order, during which he shall earn increment pay if due, and on expiry of the penalty period, the reduction will not be effective such and such to censure from major penalty to minor penalty. Then whereas CMD appellate authority had authorized such and such, then the next page, 75. Now therefore I, Chief Manager, appellate authority CIL so and so, moderate the major penalty of reduction of 2 stages to censure. Lordship got it. Then, my lord, what happens, my lord? I make a representation on page 86, 3rd July 2023. Well, I'll cite the judgments later, my lord, so that I can place the
To the chairman, yes.
Yes. This is 3rd July 2023. I make this represent to the chairman, Coal India. With a prayer at page 92 at the bottom.
Yes.
For the reasons above, I fervently request your good self to reconsider and or revisit the issue and receive. My
Matter will continue. That is what.
it will continue for some time. It will.
Okay, so other matters stand released.
We are very happy, my lord.
আপনি একটু ভালো করে ঠান্ডা মাথায়
Okay. You requested to reconsider and revisit the issue and to cancel and withdraw the punishment.
I said you revisit the issue and withdraw the punishment of censure. Now, my lord, lordship kindly takes up my supplementary affidavit. This was filed pursuant to leave granted by the court. I had given them a copy. There was a direction upon them to file an affidavit to this supplement as well, but that affidavit has come. Today, my lord, I find my lord, none has come on the Coal India. They are deliberately not coming.
Oh.
That I have said already. Lordship kindly says, just hurriedly I take your lordship to this para 2, page 2.
Yeah.
I state that respondents have not filed an affidavit in opposition to the petition despite the orders passed by the Honorable Court on such and such date. Consequently, the statements made in the so shall be deemed to have been admitted by them by applying the doctrine of non-traverse. I did not tell your lordship. Lordship is well aware of this. Then, this is very vital. 3. During the pendency of the writ petition and while this Honorable Court is in session of the matter, the review representation dated 3rd of July just placed, made by me, which is annexed as a PA to the petition, has been allegedly dealt with and disposed of by the board of CIL, upholding the punishment of censure imposed upon me by an order bearing so and so. That is that page, that is P9. If your lordship takes this P9. Interesting part is P9,
Yes.
P9, it is page 5. It ends at page 8. If I may place, then I'll have to. Well, the penultimate paragraph. I just penultimate paragraph at page 8. The contention of Sri Subodh Kumar is devoid of any merit. In italics, lots you got it. After considering all the facts and circumstances of the case, documents on record with due application of mind, CMD CIL appellate authority had taken a lenient view by moderating the major penalty deduction to 2 stages. Lower in time scale of pay for a period of 6 months from the return of sergeant to the penalty of censure for moderating the penalty of sergeant. Now, therefore, this is the appellate authority's order of censure that is quoted here, and then now, therefore, the board, Lordship notes this board deliberated upon the proposal in detail and was of the view that penalty of censure as imposed by vide 30th of August 2022 order upon Sri Subodh Kumar calls for no change and needs to be upheld. Hence, next page. Hence, after further deliberations and making into consideration the facts, taking into consideration and the facts and circumstances of the case, the board upheld the penalty of censure imposed by CMD CIL appellate authority of Sri Subodh Kumar, Sergeant Sir. The review application is stands disposed of. My lord, this is a very, very vital document, my lord. This is, my lord, clear interference with the courts of justice. The court is in season of the matter. You don't have time to file affidavits, but you have the time to deal with a representation for revisiting the issue, which is part of the petition. You don't file, they don't file an affidavit. And you have just with a view to, my lord, rendering my writ petition infructuous or rendering me non-suit. This is the most malefied act on the part of the most important part is I was charged by the disciplinary authority, who is now the board chairman. So the DA has acted as the previous, the earlier
Authority to revise the appellate authority's order.
Yes.
Act has,
This is Lordship kindly sees this is how this administrative arrogance, I should say. The matter is pending before this court. 3 or 4 directions, my lord, so many notices given. The matter was still hard in part without the affidavit. 8,500 cost was imposed upon the for non-filing of affidavit. That nothing was done. Then when the supplement affidavit was this is on record, on there was a direction to file opposition to the supplement. They have not come with the affidavit. Now, my lord, just to frustrate the writ petitioner and to render the petition non-suit, my lord, this which has to be considered by the High Court by on affidavits or otherwise, my lord, they have passed an order dealing with this 3rd July 2023 order. And who deals with it? This is being dealt with by my disciplinary authority when he was CMD CCL. Now he is the board CIL chairman. So my lordship kindly sees how it is the act is infected with bias and malice. And the same person, no one can be the judge of his own cause. These are very well-known propositions of law. But lordship kindly sees how this matter has been dealt with. This is such a case. No. I just want few paragraphs then.
Yes.
Well, I just, because this is very vital. When charge sheet was issued to me by one Mr. Prasad, who was chairman cum managing director of CCL, my disciplinary authority.
Chairman cum MD.
Yes, of the Central Coalfields Limited.
Yes.
Now, when I prepared the appeal against the major penalty imposed upon me, then the appellate authority was one Mr. Agarwal, who was the then chairman CIL. Now the
Yes.
now the present board of CIL is headed by my then disciplinary authority, who is now the chairman of the board of the CIL board, and he takes up the he disqualifies himself to be the judge of its own cause. He imposed upon me the major penalty, which was reduced by the then appellate authority to censure. Now, as a chairman of Coal India and heading board of CIL, he passes the order
On review petition.
on review petition during the pendency without taking leave of the court. This is clear case of interference. I could take out a contempt petition, but then I thought the matter is pending here, and contempt petition will drag the proceedings further. So, my lordship, kindly is what I have said, and paragraph 4 of the supplement affidavit is a very short one. It's not very big one.
Yes.
Perusal of order dated such and such shows that board has disposed of review application dated 3rd of July 23 mechanically without assigning reason whatsoever. It is alleged that the board deliberated on the proposal and further deliberated taking into consideration the facts and circumstances of the case for upholding the punishment of censure. The board has not specified the facts and circumstances allegedly considered by it, and how and in what manner they have been considered, the same, leading to the inevitable conclusion that there has been no consideration at all, and the alleged deliberation is a bald allegation being devoid of material particulars. Then, the respondent did not obtain leave of this court before passing the order dated such and such. They have interfered with the course of justice, ignoring the pending adjudication of the list by this honorable court. I am rendered non-suit. The purported order dated such and such is aimed at frustrating the instant date petition. Then, paragraph 6. They have deliberately not filed the opposition despite 2 orders of the honorable court and have circumvented the same by passing the order dated 1st of February 2024, illegally betraying executive high-handedness. The order dated 1st of February 2024 is illegal, arbitrary, and is infected with malafide and bias, and hence unsustainable and liable to be set aside. Then I finish it. I say that by my wife, Monica Singh, manages her own income and is a regular taxpayer, which will be evident from the tax returns being filed by her for years. She entered into agreements with the seller to buy the shop number 201, 242, and 243 at Bokaro Mall, Jharkhand, in her own name on 3rd of June 2021. That is much after the charge sheet was issued to me. This is very vital. That's what I said, it's cart before the bull. Then I gave financial accommodation to my wife from a tax-paid salary account for purchase of the shops by her in her own name. I provided fund to my wife by way of gifts who wanted to purchase the shops in her own name. So I was not the prospective purchaser. I was fastened with the disciplinary proceedings for prospective acquisition of shops by my wife. As you can note this, fastened to the charge sheet for prospective acquisition of shops by my wife. So, this this supplement affidavit, leave was granted to file it so that the subsequent event may be considered and disposed of to avoid the multiplicity
Multiple proceedings, yes.
This is the supplement affidavit. Now, I'll just cite a few judgments. 63 63. I just cite few judgments. 63 Supreme Court are there.
Regarding acceptability of the supplementary affidavit.
No.
Oh.
This is the new charge framed by not only the inquiring authority but also by the disciplinary
authority. Different charge.
By the appellate authority itself. The earlier appellate authority, not the present appellate authority. Present appellate was my disciplinary authority. Now, the in between the appellate authority, Mr. Agarwal, he took a very fair decision. But he also contradicted at some places. I have shown to your lordship. But ultimately he said this should be reduced to censure. And after observing and recording all reasons in support of that. Now, the present, because this if censure continues, then I am deprived, I am continuing to deprived of the promotional prospects for all time till my retirement. I will not get any promotion. That is the purpose. The vindictive attitude of the authority, my lordship kindly sees. He ought not to, he could recuse himself from the deliberations, if any. But the deliberations is in the air. Where is the deliberation? My lordship kindly have a look to the page 8. Page 8
Of
the supplementary affidavit.
yes.
Why I am showing? Because it is there.
When it was served upon you.
Lordship,
When it was served upon you.
it was served upon
Order dated 1st February 2024.
much after the filing of the writ petition. Writ petition was filed in 2023.
Oh, you affirm it on 18th day of March 2024. So you have handed over this
Father said, yes,
copy, yes. Okay.
Of course.
Yeah.
And Malad, this that's what I said, Malad, this is a subsequent event. The court granted me to bring on record by filing a supplementary affidavit. And I have prayed for quashing of this order because this doesn't Malad hold good at all. Malad, lordship kindly sees the board deliberated on proposal in detail. How and in what manner there was deliberation? What was deliberated? Nothing is appearing. It's a totally unreasoned order. So non-speaking on the face of it, it is liable to be set aside. And this is only to repeat the attitude that he was inimical to me while he issued the charge sheet. The inquiry officer said article of birth partly proved, article of truth not proved at all. He said no, all proved, and imposed upon me the major penalty. Lordship kindly sees. I preferred appeal. Appellate authority, considering all, said no, it should be due to the censure, it's a minor penalty for 6 months. Now, again, when he has become chairman of Coal India and has assumed the role of this my appellate authority again and heading the board of Coal India, he has again taken up the matter and repeated that yes, because he cannot go back to that. At least he has shown that generosity that censure has been repeated, that it should remain. This is the outcome of the personal vengeance, I should say. And the lordship kindly. This I just hurriedly take to 2-3 charges, not many.
Yes.
But so far as the new charges concerned, I cite one 1963 Supreme Court. This is 1960 1963 Supreme Court 1914. Kindly have a look, just relevant. This is paragraph 5 only. Paragraph 5. There is again the curious circumstance that while the domestic tribunal recommended the dismissal of Manik on a charge of having deliberately caused damage to raw materials, the order of dismissal passed by the management was not in respect of this misconduct, not of respect of this misconduct. The order in terms of mentions that you were dismissed from service of the company for causing willful insubordination or disobedience, whether allowed or in combination with another or others, of any order of the superior or of the management. It appears that the charge sheet, which was sent to Manik on 23rd October 59, did not mention any charge of willful insubordination and disobedience. It is quite clear that the domestic tribunal did not find him guilty of an insubordination or a disobedience. It is difficult to understand how the charge, being for causing damage to property and the inquiry officer's report being in respect of the same, the dismissal order was made for something else. That itself would be a sufficient ground for setting aside the order of dismissal. So, this is a well celebrated judgment of HON'BLE case. And then, I just cite another judgment. 2008, volume 3. Okay. That so far as this that even the appellate authority and reviewing authority must give reasons. The order of reviewing authority, which is infected with bias and malice, I have said, it is the 2008 volume 3 469. ওটা দিয়ে দাও 469 টা দিয়ে this is 2008 volume 3 SCC 469 paragraphs really 14 12 20 and 21.
Yes.
I just my lord, 14. In support of his aforesaid submission, Mr. Gauranga Rao referred to a constitutional decision of this court in the state of Madras, Srinivasan, which was a case involving compulsory retirement of a civil servant in which the aforesaid question has arisen. Repelling the argument of Mr. Shetalbhad, and even while affirming an order, an authority acting in a quasi-judicial character should indicate some reasons as to why it accepted the findings of the lower forum. This court held that having regard to the material which is made available to the state government, it would be somewhat unreasonable to suggest that the state government must record its reasons why it accepted the findings of the tribunal. This court went on to observe further that even while differing with the order of the lower forum, the state government was merely required to give reasons while it differs, though it was not necessary that such reasons should be detailed or elaborate. The conclusion arrived at by the constitutional bench was that where the state government agrees with the findings of the tribunal, which are against the delinquent officer, it could not be said as a matter of law that the state government could not impose penalty against the delinquent officer in accordance with the findings of the tribunal unless it gave reasons to show why the said findings were accepted by it. Then will also kindly take smaller 20. It is no doubt true that an appellate or revisional authority is not required to give detailed reasons for agreeing or confirming an order passed by the lower forum. But in our view, in the interest of justice, the delinquent officer is entitled to know at least the mind of the appellate or revisional authority, mind of the appellate or revisional authority, both. The revisional authority, board, and appellate authority, chairman CIL. Here the reviewing authority has not assigned any, only said consider deliberations after deliberations in detail and all. What deliberations? What considerations? That must appear from the record. It is true that no detailed reasons are required to be given, but some brief reasons should be indicated even in the order affirming the views of the lower forum. Then, to having regard to the above, we are not inclined to interfere with the order of High Court, and appeal accordingly dismissed. Then, my lord, this another judgment, my lord. Or should I cite this judgment of in Sheikh Bahadur's case that no link has been established? I should cite 2002. 2002, Malad, volume 7 SCC 142, paragraph 7, only one paragraph. Copy. 2002 barcode. So may I hand up the judgment? This is Malad Sher Bahadur Bas Union of India, 2002, volume 7, SCC 142, paragraph 7.
Yeah.
This paragraph 7.
Yes.
Well, I just middle portion. I'm just omitting towards the middle of paragraph 7. Yeah, the inquiry officer examined the charged officer, but nothing is elicited to connect him with the charge. Because you got it well. The statement of the appellant recorded by the inquiry officer shows no more than his working earlier to his re-engagement during the period between May 78 and November 79 in different phases. Indeed, his statement was not relied upon by the inquiry officer. The finding of the inquiry officer that in view of the oral documented and circumstantial evidence, the charge against the appellant for securing and fraudulent appointment letter duly signed by the said APO constable was proved is in the light of the above discussion erroneous. In our view, this is clearly a case of finding the appellate authority of the of charge or appellant guilty of charge without having any evidence to link the appellant with the alleged misconduct. I am on the here. Well, the charge is that my wife acquired some property, which was done after which was done
Issuance
long
of
after
charge
the
sheet.
issuance of charge sheet. That's why the alleged misconduct could not be linked with the alleged. What is the alleged? Nothing is on record. Lordship, and is the no link.
No evidence linking the
Alleged misconduct. Therefore, this is very vital for my case. The other judgment, my lord, I just 87 to SCC, 87 to SCC. My lord, this Bridgemount case.
Din. Yes.
This is, my lord, 1987 to SCC 188, paragraph 7. My lord, in the charge memo, as well as in the finding, there is a charge against me that in 2008, I was imposed upon a punishment of censure. But thereafter, in my case, I have said on oath in my petition, I have got 3 promotions. So, Maladi, it's like the original principle. The misconduct defender stands wiped out because of subsequent acts of the promotion. He didn't, the Maladi, the Maladi authority, the punishment of censure imposed upon me in 2000 did not weigh with the authorities while considering me and giving me promotion thrice thereafter. So here, Lordship kindly sees paragraph 7 I am reading. It's also the middle part. I am not. No.
Adverse entries awarded.
It is now well settled. I start from there. After 10, 12 lines, it is now settled that adverse entries, if any, awarded to an employee lose their significance on or after his promotion to a higher post. I need not place the other part. This is the ratio of this judgment. Then, my lordship, kindly have a my lord, this 2023 that is. I'll since my lord 2023 volume 3 SCC 622 paragraph 11.
Yes.
The last sentence.
Perversity, yes.
Yes. But the last sentence, as observed and held, that only in an extreme case where on the face of it, there is perversity or irrationality, both are present in my case. There can be a judicial review under Article 226 or 227 or under Article 32 of the Constitution. This is Mala 2023. Only for this sentence, Mala, I thought I should cite this. And Mala, yes, Lordship. Here, Mala, this 71 Supreme Court. I'll cite one more judgment, my lord. KIR 1971 Supreme Court. State of Punjab versus Ramjilal. This is SCC 1970, volume 3 SCC. Yes, 602. Oh.
Yes.
May I hand up? Lordship text paragraph 9.
Yes.
counsel for the state of Punjab contended that the plea that the action of the state was not bona fide, it cannot be said to be established unless the party alleging that case names the officer or officers guilty of conduct which justifies an inference that official act was done for a collateral purpose. And since no such attempt was made and the High Court did not find that any named officer or officers was or were responsible for that official act, the plea that it was bona fide must fail. We do not think that the law casts any such burden upon the party challenging the validity of the action taken by the state government. The state government has undoubtedly to act through its officers. What matters were considered, what matters were placed before the final authority, and who acted on behalf of the state government in issuing this order in the name of the governor are all within the knowledge of the state government, and it would be placing an intolerable burden in proof of a just claim to require a party alleging malafide or state action to aver in his petition and to prove by positive evidence that a particular officer was responsible for misusing the authority of the state by taking action for a collateral purpose. This is for a, I need not make him a party by name. I thought they will come and argue. So I brought this judgment. I need not make somebody make a party. It is done for a collateral purpose. If that is so, then I need not make somebody a party by name. That is what is Supreme Court says in paragraph 9.
Yes.
First, just a minute, Mal. First of all, I just I just this is Lordship, one more judgment I have to cite. This is 1987 4 SCC 611. 611. It's the Lordship kindly sees here. This yes, I just this is on the question of bias.
Oh.
This Lordship, this I just read paragraphs 15, 16, 17, and 2022. But I read from page 612.
16 to 18.
Yes.
Okay.
15, 16, 17, and 2022.
15 to 18 and 22.
Yes.
Yes.
15, 16, 17, and 2022.
Oh. Yes.
I just placed this Procedural Lordship's time, page 62. I just read the quoted held. Lordship, kindly have a look to page 612. 612. It is the essence of a judgment that it is made after due observance of the judicial process, that the court or tribunal passing it observe at least the minimum requirements of natural justice and is composed of impartial persons acting fairly and without bias and in good faith. A judgment which is the result of bias or want of impartiality is a nullity and the trial quorum non judice. The test of real likelihood of bias is whether a reasonable person in possession of relevant information would have thought that bias was likely and whether the authority concerned was likely to be disposed to decide the matter only in a particular way. What is relevant is the reasonableness of the apprehension in that regard in the mind of the party the proper approach for the judge is not to look at his own mind and ask himself, however, honestly, am I biased? The question mark. Lord, you can see how eloquently it is put. But to look at the mind of the party before him. In the present case, having regard to the antecedent events, the participation of the officer concerned in the court-martial rendered the proceedings quorum non-judice. The participation of my disciplinary authority in the review as a reviewing authority renders is totally illegal and is nullity and in the language of the Supreme Court non-judice. Quorum non-judice, I'm sorry. So, my lord, this is on the bias issue. And my lord, I could bring, my lord, a number of judgments, but I have not. The last judgment I am citing, this is 1973 for SCC 94. This is on the point of the doctrine of non-traverse. If no affidavit is filed, but I must equip your lordship because the doctrine of non-traverse comes into play. But here, my lord, this more or less same facts. That's why this is an old judgment, but it's a gold. But if your lordship, my lord, here, my lordship, if your lordship, my lord, holds the again, I don't know any order that may be passed by your lordship. Your lordship has to write what consider the orders passed by this court serially. So many orders, so many chances given, but the affidavit has not come. And here the Supreme Court says, but
yes,
this is one of the here, my lord, the paragraph is relevant. Paragraph is, my lord, this 11 and 12.
Oh,
11 and 12 is the relevant paragraph.
yes.
Not a very long judgment. I just placed paragraph 11. Mr. V.S. Desai appearing for the appellant argued that the High Court erred in rejecting the appellant's application for filing their counter affidavit and thus enabled them to challenge the correctness of the statements made by respondent number 1 in his two special civil applications. He also argued that the appellants were not to be blamed for not having filed their counter affidavit in time, since they were under the impression that the special civil application would not be proceeded with after the government had cancelled this said notification. That notification, however, was cancelled on June 20, 1965. Before the date, the appellants had obtained adjournments and had got their special civil applications put off for hearing beyond the summer vacation only on the ground that they should have time to prepare and file their affidavit. Though the appellants had thus obtained time, they did not file their affidavit even on the reopening of the High Court. Even when the special civil applications ultimately reached hearing on June 20, 1965, the counter affidavit was not ready and was not filed. Indeed, counsel for the appellants was not even present when the special same facts are here also. Same facts are here. So here, Maladi, in this circumstance, it is impossible to find any fault with the High Court for refusing to allow the counter affidavit to go on record at that later stage, apart from the question of delay, as would have meant for further adjournment. So, the doctrine of non-traverse comes into play. Repeated chances were given, they have not come with an affidavit. Even today, even though no submission is advanced by any of their counsel. And Malad, I can show to Lordship at least 10, 20 notices given to him for mentioning or for listing the matter.
Okay, that's all.
Yes, Malad. So, Malad, Lordship,
Just by direction.